Hi everyone, I'm Dale Smith, aka Journo Dale, and we're here to talk about Canadian politics. A new Supreme Court of Canada Justice was named this week, Michelle O'Boswin, and she is going to be the first Indigenous member of the Supreme Court of Canada. And I figured I would talk a little bit about the process by which we appoint Supreme Court justices in Canada, because we are familiar with the drama that happens with the nomination process and the confirmations and so on in the US, but a lot of people are far less familiar with how this works in Canada. So first of all, there is the criteria for which a Supreme Court justice can be nominated. And in Canada, under the Supreme Court Act, it is anyone who is a judge on a superior court or a barrister or advocate of at least 10 years standing in the bar of a province. And that also includes, for example, law professors and people who are still in practice. You don't need to actually be a lower court judge in order to make it to the Supreme Court of Canada. We've had justices before who were appointed directly from law schools, and one of the current judges on the Supreme Court was working in a firm when she was named to the bench. So it does allow for some variety of experience there. You don't just need to be a judge currently. The new one, Justice O'Bonswin, she has been a Superior Court judge for about 5 years. And she was not on the Court of Appeal. So there is that particular factor in there, in that some of her judicial experience is far lighter than some others of her peers. But that aside, those are the kind of baseline criteria. A Supreme Court of Canada justice, like any other judicial appointment in Canada, is a governor and council appointment, which means it's something that the Governor General makes on the advice of the Prime Minister and Cabinet. With judicial appointments, it's usually on the recommendation of the Justice Minister, and how they get to that recommendation is a bit of a process. For most judges, there's an appointment process with advisory councils in the different provinces, and you have people who, under the current system, people submit applications to those committees, who vet them and then forward them on to the Justice Minister, who then vets them again and then creates short lists for appointment, which happen. For Supreme Court justices, it has typically, up until Paul Martin was Prime Minister, simply been a governor and council appointment on the recommendation of the Justice Minister. But when Paul Martin was Prime Minister, they started mixing things up a little more and trying to create a slightly less opaque process. And part of that involved having the Justice Minister appear before committee in order to answer questions as to why he made that particular recommendation for those judges, as well as having some kind of a process by which the nominees would appear before a parliamentary committee and answer questions, but not in the same way as the American confirmation process works, in that they wouldn't allow them to ask hypothetical questions about how would you rule on certain cases, or, why did you rule a certain way on those cases. And that's kind of a rule in Canada, is we don't ask judges to comment on their rulings because the rulings are supposed to speak for themselves. So Paul Martin's government started this ball rolling. Stephen Harper's carried it forward a little more, and started this process by which they were going to get a committee of parliamentarians to create the long and short lists. But that turned into a bit of a problem, in part because these committees were still dominated by the Conservatives, and it allowed them to kind of launder the accountability. So when the issue with Justice Nadon came forward, and we'll get to that in just a second, what they ended up doing was saying, well, the committee recommended. And you had people in the committee who were like, I swore an oath to secrecy, so I can't really say anything, but that's not really how it worked, without getting into specifics. And so that whole appointment created a bit of a firestorm. What the issue was because it was for one of the 3 mandated seats in Quebec. And the reason why Quebec is guaranteed 3 seats on the Supreme Court is because Quebec has a separate legal system. The rest of Canada uses a common law system. Quebec uses a civil law system. And therefore, it's imperative that you have enough civil law practitioners on the Supreme Court to rule on those cases. So that's why Quebec has 3 specifically mandated seats. And what happened in the Nadon appointment was he was not a member of the Quebec bar. He was a federal court of appeal judge. And there was a question as to whether that could count toward the requirements for the Quebec bar in terms of being eligible for appointment. That ended up becoming a bit of a firestorm that went on a reference to the Supreme Court. The Supreme Court said no, that appointment didn't qualify. They nullified it. And after that, Stephen Harper just started appointing without a process for the remainder of his time in office. I will pause and say for a good read on the Nadon appointment and everything that happened, 10th Justice by Chris Mamathan and Michael Plaxton. Excellent read, quick, easy, and a really good overview of what happened in that situation and why it matters to Canadian law. So yes, the rest of Harper's appointments were all pretty much directly, no process, no parliamentary hearings, none of it. It was just a phone call saying, would you like to be a Supreme Court judge? And they said yes. So when Justin Trudeau came to power, he decided to restore a process for appointing Supreme Court judges. And he did it in a way that was slightly different, again, from how it had been done before, by creating an independent committee to kind of go through that process. And it was done similar to how he did his Senate appointment committees, and that's quasi based on the model that Harper started for vice-regal appointments, which Trudeau then jettisoned and then replicated for senators and, to a certain extent, Supreme Court judges. And anyone who's read my columns recently knows I have strong feelings about jettisoning the vice-regal appointment committee process. But suffice to say, the big difference between what is happening with these appointment processes now versus before is that they require people who want to be a Supreme Court judge to put their name forward. It's less about them seeking names from the judicial or the legal community, like used to happen. The Justice Minister used to go to the bar associations and legal associations and so on and try and canvass who would be good picks for those regions, because we have regional seat distribution on the Supreme Court. But now the process requires that they apply, and that can create its own particular dynamics in terms of people who apply for positions like this tend to have a different kind of conception of ego as for someone who was appointed without putting their name forward and being asked to serve in that capacity. So that's another dynamic that's kind of in play, but we're going to kind of set that aside for now because it's just more about the process in terms of there's now this independent committee, and they create the short list that goes to the Justice Minister and the Prime Minister. So it's trying to be a little more arm's length about it, trying to be slightly more transparent. And one of the ways in which the transparency happens is they will make public the questionnaire that the successful candidate submitted as part of their application. And we did see that again this last week with Justice O'Blancwin's questionnaire being made public when it was announced that she was being named. There is still going to be some kind of a parliamentary committee process in order to hear from the justice herself. But those questions are, by nature of this process, going to be fairly superficial. These committee processes have been really uneven in the past. some of the early ones under the Harper era were kind of there were instances where there were MPs being tremendously rude to them because they didn't think their bilingual qualifications were sufficient, and other ones where the questions were being asked for things like who are your heroes and things that are slightly superficial, because we're not supposed to ask what is your position on X issue, or why did you rule in this case in a certain way, without getting into particular specifics. So these processes are not terribly helpful. It's just more of a get to know you. More useful are when you have the Justice Minister being asked by these committees why you chose this person, or why, and then putting their name forward. And that's more important in our system for accountability reasons, because under responsible government, it is the Prime Minister and the Justice Minister who are accountable to Parliament for these decisions on these appointments. So that's why that particular process is important with the ministers being asked questions, but less so with the justices themselves. And like I said, it's just more of a kind of casual get to know you, meet and greet, and a means of letting the Canadian public get a first glimpse into who this judge is. We don't have a date yet for when this committee is going to happen for the new one. It's likely going to be this week at some point. So by the time this video goes to wide release, we may have a date by then. But suffice to say, that's kind of the process by which these things happen. It's far less dramatic and far less partisan than in the US and in some other countries. And as a result, our court is much less dramatic, much more staid. There's kind of the joke that people don't know who Supreme Court of Canada justices are when they know who they all are in the US. I don't know that that's necessarily a better thing, but it's just kind of a reflection of how far less, I don't know if dramatic's the right word, but we don't have the same kind of partisan stakes that the US does. For the longest time, I had a joke about the most contentious issue at the Supreme Court of Canada was the standard of review for administrative law decisions, and how that created lots of split decisions on the Supreme Court, and why this has kind of been, like I said, it was one of the more contentious issues, and it's like so completely removed from everything we hear, how we conceive of Supreme Court issues in other countries like the US, where you've got abortion and same-sex rights and so on, that are being still litigated in their Supreme Court, whereas in Canada, it's like that's really not even an issue for our court. And yeah, they're much more wound up about how to deal with administrative tribunal decisions. So yeah, that's kind of the process. We'll see what the committee hearing is like this time. But suffice to say, we are about to have our first Indigenous Supreme Court of Canada Justice. Some people say it's been too long. The kind of flip side to that is that there wasn't a lot of talent in the pipeline, but we're reaching a point where it's getting there now. So we're going to start seeing more of these kinds of appointments going forward. And our Supreme Court is getting a little more diverse. So that's where we are. And that's everything for this week. Join us again next week for some more Canadian politics. I'm Dale Smith. That's at journo_Dale on Twitter. And don't forget to like the video, share, subscribe, and support us on Patreon. Thanks, everyone.